Welcome to the compliance updates for August 2022 in the Midwest region. Starting in Illinois, we have a few high-level updates. The Pritzker administration issues third wave of conditional adult use cannabis dispensary licenses. So third wave, we've had two more before this, super exciting. These awardees will join the 177 conditional licenses issued by the administration in July, bringing the total number of issued licenses to 182 of the 185 that are available. All businesses qualify as social equity applicants under the Cannabis Regulation and Tax Act. The list of today's awardees and the next steps of the conditional license period are available on the IDFPR's adult use cannabis website. Of the businesses selected through the lottery, 41% are majority Black owned, 7% are majority white owned, and 4% are majority Latino owned, while 38% of awardees did not disclose the race of their owners. Exciting stuff in Illinois. And another one out of Illinois. So the governor announces a record-breaking $445 million in fiscal year 2022 adult use cannabis tax revenue. Wow. So the governor announced today that the state of Illinois has seen a 50% increase in total tax reported from adult use cannabis, from almost $300 million in fiscal year 2021 to $445 million in fiscal year 2022. Total adult use cannabis sales also rose 50%, increasing from $1 billion to $1.5 billion respectively. Cannabis tax distribution to local government saw a significant jump from fiscal year 2021 to fiscal year 2022, increasing 77% from $82.8 million to $146.2 million. Under Illinois' adult use cannabis law, 25% of tax revenue generated from cannabis sales must support communities that economically distressed, experience high rates of violence, and have been disproportionately impacted by drug criminalization. That's super exciting. All right, shifting gears on over to Michigan. So in Michigan, marijuana-infused products and edible marijuana product the maximum THC limit. So the intent of this technical bulletin is to publish the list of maximum THC concentrations for marijuana-infused products. For allowable potency variants for packaging, please reference this bulletin. Rule 4 in the marijuana-infused products and edible marijuana product rule set, R420.404. A marijuana sales location shall not sell or transfer marijuana-infused products that exceeds the maximum THC concentration established by the agency by more than 10%. For the purposes of maximum THC concentration for marijuana-infused products, the agency shall publish a list of maximum THC concentrations and serving size. The total Delta 8 THC concentration in marijuana-infused products may not exceed 10%. The total milligram of THC or the sum of Delta 8 and Delta 9 must not exceed the maximum limits below. Example, the total maximum THC concentration for adult use marijuana gummy containers, 200 milligrams THC. Therefore, the maximum concentration of Delta 8 allowed in the package is 20 milligrams. Additionally, the product must follow all guidelines for homogeneity so that the Delta 8 THC is evenly distributed throughout the product. Awesome, because I've been working through this with some Michigan clients, and this has definitely been a bit of a challenge. So I'm really glad that they made an updated bulletin for this. And you know, Michigan's so great about just being so clear and concise with all of their regulatory requirements that this is one of my favorite states to operate in, that's for sure. From a regulatory clarity level, let me preference that. All right, CRA presents an adult use licensing step-by-step resource presentation. So just wanted to let you know, if you're looking to get licensed in Michigan, CRA does such a great job with all of their resources, like I just said in the previous update. So definitely take a look at this if you're looking to get licensed. It's a step-by-step resource presentation that's really great. I took a look at it. And a quick metric bulletin, so enabling patient adverse response for employees. So for reporting for adverse reactions has been streamlined to include a standard form for licenses to utilize when reporting adverse reactions to the agency. The form can be found within the email update from CRA. And the administrative rules require adverse reactions to be reported to the agency and additionally in the statewide monitoring system. Please refer to the bulletin, which provides step-by-step instructions. So real quick, this is the metric technical bulletin of all of this. I absolutely love this. I am stoked that Metric allowed for this functionality for Michigan. They really should, do this in all of the other states and really streamline and standardize this entire workflow. Actually, in the Northeastern region compliance update, I go into a little bit more best practices for adverse events and reporting and streamlining those different types of operations. But just to repeat that, you should have a communication plan. So it is extremely important that you standardize and systematize this entire workflow around adverse events. Remember, adverse events or product complaints are different than product recalls. So you do want two different SOPs, two different workflows, two different forms, what have you, but they're going to be similar communication plans. You just want to make sure that you're capturing all the information and all of the data and effectively communicating that to your consumers and making sure that the public is staying safe. So take a look at this Metric bulletin. Remember, Metric also has that bulletin archive now on their website too, so you can search by state with that archive and find everything that they've pretty much have ever posted. But as you can see, the adverse response is now under the patients tab here in Metric. And CRA is just releasing a public notice announcement and request for comment. So some stuff going on with regulatory changes as always. So the agency has been hearing concerns that the supply of marijuana produced by licensed growers exceeds or may soon exceed consumer demand. The concern includes that the wholesale price of flower is lower than the cost of production or will be when harvests are high in October. And so they're just trying to work through that. I'm really glad that they're being proactive about this. I mean, don't get me wrong. I definitely think that the price point should be low so that everyone can access cannabis. But it's definitely a problem when the cost per pound is lower than the cost it is to produce it. So we're figuring it out, but this is pretty standard in all of the different metrics, all the different states, not even metric states, all the different states struggle with this. And another really great resource out of CRA. So Michigan expectations for maintenance for standard operating procedures. This is just like a really high overview of what they expect and what type of SOPs and things like that you should have. And specifically which rules require what type of SOPs. Gosh, I just love this so much. This is so great. I really wish that other states would take into account what Michigan is doing. This is just so clear, concise, straightforward, cutting down on labor costs and everything else. And also just the best practice here, you really should be reviewing your SOPs at least twice a year, ideally quarterly. And you really need to not only review your SOPs to make sure that they're up to date with the regulatory requirements. Two, you also need someone else from your team to inspect them to make sure that they're the true workflows that they're doing within their operation, because you really don't want a deviation between your SOPs and what's actually happening within the operation. Three, this is also great to gain clarity to make sure that someone else can review your SOP and know what to do with them. And four, you also just want to make sure that you have your SOPs in different style of formats. So like have a workflow diagram, a checklist, an effectiveness criteria. All of these things are really important within your SOPs because we all learn differently. And so we want to make sure that we're giving abundant amount of resources so everyone can digest the information and you can transfer the knowledge more effectively. And let's shift on over to Minnesota. Yeah, we didn't see this one happening. So Minnesota hemp edibles law ushers in new rivals up into marijuana market. Yeah, you wouldn't say. So Thanks to the new state law, the Minnesota marijuana market has been turned upside down now that an untold number of businesses are selling hemp-based edibles that contain enough THC to get consumers high. Sorry, I can't help but laugh at this because it's just like, whoop, let's just go for it, which is great, but it's yeah, it's obviously causing issues. The new law thus created a default recreational THC hemp market while adult use marijuana sales remain illegal in Minnesota. As MJ Biz chief correspondent John Schroeder notes that could cost the state's 2 registered medical marijuana businesses some serious market share since they were allowed to begin selling marijuana-based edibles only on August 1st, a month after hemp edibles debuted in the state. The situation also opened a new business opportunity for out-of-state hemp good manufacturers who could end up supplying retailers in Minnesota with legal hemp-based edibles that contain, under the state law, up to 50 milligrams of THC. And the lack of state regulations means, in the words of one cannabis attorney whom John spoke with, that, quote, if you can afford to rent a storefront, you're ready for business. That's why, end quote. That's why several industry insiders told John there is now a, quote, miniature green rush, end quote, going on in the state, one with the immense business opportunities. Only time will tell how long the window of opportunity will last. However, since the state and local governments are all but certain to issue new regulations at some point. I love it. It definitely adds a lot of complications, but free the weed. Just some high level, legalization initiative will appear on November ballot in Missouri. So just some level things to know here. Adults 21 and older could purchase and possess up to 3 ounces of cannabis, which is great. They could also grow up to 6 flowering cannabis plants, 6 immature plants, and 6 clones if they obtain a registration card, which is pretty cool. So that's a total of 18 plants between immature, veg, and flowering. I'm a huge proponent of home grow, so I love that. The initiative would impose a 6% tax on recreational cannabis sales and use revenue to facilitate automatic expungement for people with certain nonviolent marijuana offenses on their records. Remaining revenue would go towards veterans' health care, substance misabuse treatment, and the state's public defender system. The Department of Health and Senior Services would be responsible for regulating the program and issuing licenses of cannabis businesses. Regulators would be required to issue at least 144 micro-business licenses through a lottery system, with priority given to low-income applicants and people who have been disproportionately impacted by the war on drugs. Existing medical marijuana dispensaries would also be first in line to start serving adult consumers with dual licenses. Dual licenses is the key there. So they're looking at 2 different markets, 2 different supply chains, medical versus adult use. Michigan model, Massachusetts, Colorado, those are all those types of models. So essentially you're managing 2 different types of inventories, which is a pain in the ass based off of my assessment here. But if they did something like Oregon or California with a single supply chain and the point of transaction is what determines medical or adult use, that would be ideal. But, we're learning. Where was I? Regulators could create rules around advertising, but they could not be any more stringent than existing restrictions on alcohol marketing. Love that. Public consumption, driving under the influence of cannabis, and underage marijuana use would be explicitly prohibited. A seed-to-sale tracking system would be established for the marijuana market. Local jurisdiction would be able to opt out permitting cannabis microbusinesses or retailers from operating in the area if voters approve the ban of on the ballot. The measure would further codify employment protections for medical cannabis patients. Medical marijuana cards would be valid for 3 years at a time instead of 1, and caregivers would be able to serve double the number of patients. Love that. I love a caregiver model. A strong majority of Missouri voters, including a plurality of Republicans, support legalized marijuana for adult use. A recent poll found Payne previously led a successful ballot effort to legalize medical cannabis in the Show Me State in 2018. Legal Missouri 2022's initiative is backed by the Missouri Medical Cannabis Trade Association, as well as ACLU of Missouri, St. Louis City, St. Louis County, and St. Charles County chapters of the NAACP, all 6 active chapters of Missouri Normal, and Missouri Association of Criminal Defense Lawyers. How awesome. All right, and my last 2 updates for you today for the Midwest is out of Ohio, my home state. And also this update is provided to you by ProCanna, one of my technology partners that I am on the advisory board for. I always just like to add that disclaimer so that way you all know. But so some high-level things: change of location, app, strain names, and product item IDs. So a couple of different things just happening here. The process for the change of location is these 10 steps. So make sure that you review those and you are following that process. Strain name and product name. So all strain names must be approved by the Department of Commerce via the new strain name application submission. Of course, Ohio overcomplicating everything. So that's how you get approval for your strain names. And then some additional strain name and advertisement restrictions and product item IDs. So yeah, classic Ohio, just overcomplicating everything. And then another update, just guidance on new and renewal employee application and ID badges, and 3 different reminders. So who must apply for an employee badge? Every owner, principal owner, board member, employee, administrator, agent, or other person who may significantly influence the control of activities of a cultivator, processor, or testing laboratory must apply for the department for an employee ID badge. This includes all employees who work in the facility, including employees of third-party entities, so like consultants. If an individual is an employee of both a cultivator and processor, the individual must have active employee badges for each license, which is also absurd that you have to get badged by each operation type. There's, of course, going to be a background check. Some additional just reminders: bond reduction requirements, fee payments. Yeah, good old Ohio. I cannot wait until that opens up and actually becomes a viable state that you can operate in. So yeah, that is your compliance updates for the Midwest in August 2022.